can't you stop stealing things?
I was doing it to support my habit.
21 CR 0254, State of Texas versus Emily Elizabeth Rowland. Could I have parties announced for the record for the state,
Jordan Brown for the state.
for the
Christine
defense?
McDonald, sorry, Your Honor. Christine McDonald for the defendant.
And are you Emily Rowland?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No, Your Honor.
Ms. Rowland, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
You're going to need to speak up.
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Rowland, I'm showing you a document entitled True Bill of Indictment. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Ms. Rowland, I'm showing you a document entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with? It's theft under $2,500 enhanced as a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Rowland, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, your punishment is to be assessed at 2 years in the state jail facility. There's a $1,500 fine. State recommends community supervision. It says here there's no application for deferred adjudication. Is that correct?
Yes, Your Honor.
This will run concurrent with cause number A 1908886SB and Tom Green County. State will take in consideration County Court cause number 644392. And there's to be the CATS course. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
Yes, Your Honor.
State is at the plea bargain agreement.
Yes, Judge.
Next, I'm going to show you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Council, have there been any such motions?
No.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation of 100 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, Judge. State offers State's Exhibit 1 and attachments.
Any objections?
No objection, Your Honor.
Ms. Rowland, I'm going to show you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, we're going to go off the record for a moment. If I could see attorneys in a breakout room, please. If I could see you all in breakout room number 1. All right, we're back on the record. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Is there anything you wish to say on behalf of your client?
Your Honor, we are just respectfully requesting that the court follow the plea agreement, Your Honor. My client is also requesting if this court would allow this case to be transferred to Tom Green County.
All right, Ms. Rowland, is there anything you wish to say?
No, ma'am.
All right, Ms. Rowland, why can't you stop stealing things?
I was doing it to support my habit.
Okay, so are you doing any type of classes or anything in Tom Green? Are you on any type of program with them?
Yes, ma'am.
And what program is that?
They had me in, well, actually I go to 2 meetings a week. I also do community service. I do my payments, and then I do an outpatient counseling.
So if you're tested today, what are the results going to be?
Negative.
Okay. All right, this is what I appreciate your honesty. And part of being in a condition of sobriety is admitting what you've done wrong. So I appreciate the fact that you were honest with me and you said, I was supporting my habit. Usually people come up with all the different excuses. So I appreciate that. Do you have any children?
Yes, ma'am.
And what are their ages?
18, 16, 13, and 8.
All right. Do they live with you or they live with someone else?
They live with my in-laws. My in-laws have custody of them.
All right. Is Child Protective Services involved?
No, ma'am.
So do your in-laws have custody of your children?
Yes.
Have you ever completed parenting classes?
Yes, ma'am.
Do you get to see your children or no?
Yes.
All right. When did you complete parenting classes?
That would have been 2012.
Okay. Well, I'm going to order you to do parenting classes again because this incident occurred in 2020. I know you are in your sobriety now, but I think just you may need a little bit of a tune-up with parenting, okay?
Okay.
Do you have employment?
Yes.
All right, this is what the court is going to do. Court is going to sentence you to a $1,500 fine. That'll be probated. 2 years in the state jail facility, suspended and probated for 3 years. Transferred to Tom Green County. This is to run concurrent with A 190886 SB. Taking consideration County Court Cause number 644392. The CATS course. State, I was reading in the police report that there is a drug case.
Yes, Judge, that's TIC, the misdemeanor drug case.
Okay, thank you. 100 hours of community service restitution. NA or AA meetings 2 times per week. Outpatient treatment. And probation, if she's doing outpatient treatment on her other case, that's acceptable. But I want her to be in some form of treatment.
Yes, ma'am.
There's to be regular Zoom reporting. Random UAs. And for the people in Tom Green County, I'm going to want field visits. So, Ms. Rowland, someone will be checking up on you, coming to wherever you're living to make sure that everything's okay.
Yes, ma'am.
All right, Ms. Rowland, is there anything else that you need to be successful?
No, ma'am.
Probation, is there anything else you think she needs?
Were you going to go ahead and do the parenting class?
Yes. All right, and I don't know if CPS is involved, but I'll say CPS compliance if applicable. If there is no CPS involved, then of course you don't have to be compliant with CPS because it doesn't exist in your life. Is there anything else from either side with regards to sentencing?
Nothing from the state.
Nothing from defense.
Ms. Rowland, I'm going to show you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you, Ms. Rowland. I'm going to send you to a breakout room. Probation will meet you there, and probation will go over conditions with you.
The courtroom proceedings begin with Judge Stephanie Boyd formally calling the case and confirming appearances on the record. From the outset, the judge establishes control, carefully verifying that the defendant understands her decision to appear by video and has reviewed all legal documents with counsel. Judge Stephanie Boyd methodically walks the defendant through the indictment, the theft charge, and the serious punishment range associated with a state jail felony. Each confirmation reinforces the gravity of the moment and the consequences now in play. As the plea process continues, Judge Stephanie Boyd ensures the defendant understands her rights, including the right to a jury trial and the implications of deferred adjudication. The courtroom remains calm but tense, with the defendant repeatedly acknowledging her understanding. The plea agreement is then read into the record, outlining potential incarceration, fines, probation, and treatment requirements. The defendant ultimately enters a no-contest plea, and Judge Stephanie Boyd formally finds sufficient evidence to support guilt. The emotional turning point arrives during sentencing. After defense counsel requests the court follow the plea agreement and consider transferring supervision, Judge Stephanie Boyd directly addresses the defendant. When asked if she wishes to speak, the defendant declines. The judge then delivers a blunt, piercing question about the defendant's repeated theft behavior. This moment shifts the tone of the courtroom entirely. The defendant admits her actions were driven by addiction, prompting further probing from Judge Stephanie Boyd about treatment, testing, and compliance. Rather than reacting emotionally, Judge Stephanie Boyd evaluates the defendant's answers with precision. She questions testing results, program participation, and past conduct, clearly signaling that continued dishonesty or failure will not be tolerated. The courtroom tension peaks as the judge prepares to rule. Judge Stephanie Boyd delivers a structured sentence that balances accountability with supervision. The sentence includes a probated state jail term, a substantial fine, community service, mandatory treatment, frequent testing, and field visits. The judge emphasizes close monitoring and follow-through, making it clear that the court will remain involved. The hearing concludes with a final reminder that appeal rights have been waived, followed by a brief but firm dismissal. The message is unmistakable, excuses are over, and compliance is no longer optional.